like we're missing one lawyer. There we go. Counsel for appellant, you may proceed when ready.
Thank you, Your Honor. May it please the court, Joseph Park from Clearwater. I'm counsel for the appellant, Mrs. Chalaveria. If the court please, I'm going to reserve 3 minutes of time, if I could, for rebuttal at the conclusion of my arguments. And also, if you will allow me, I'll refer to the parties as they stood before the court below for simplicity, being the husband and the wife. This case began in 2014 with the entry of a final judgment of dissolution of marriage between Dr. Chalaveria, a very prominent cardiologist in the area, and his long-term wife. It was the final judgment of dissolution entered by Judge Muscarella in 2014. Did a number of things relevant to today. It performed an equitable distribution of the parties' assets. There are 2 assets that are effectively critical to today's analysis, and I'll describe them as Optima Health Insurance, which was an HMO that Dr. Chalaveria and many doctors had invested in, which was valued and placed on the distribution summary, and also what I'll call AFC, or America's First Choice, which is also a separate, similar type corporation, which was placed on the equitable distribution summary. The ultimate equitable distribution summary valued Optimum at $200,000 and divided it between the parties. It awarded AFC to the husband at $135,000, and that's basically the substance of what the equitable distribution said. The evidence that had been submitted in order to come up with those values was a product of the sworn testimony of the husband, taken months before the trial, as to his ownership of Optimum, as well as bank statements, financial statements that placed a value on it of $200,000. As pointed out in the trial, as pointed out in the judgment that the court rendered, nothing was ever done to dissuade the court from believing that at that time. That's the evidence the judge had and which was relied upon. Fast forward, what we know now that we didn't know then was the husband no longer owned in his name the stock in Optimum, but it had been transferred within AFC. So effectively, as the somewhat simplistic, before I used my argument, the red box. Yes, ma'am.
Okay, can you hear me?
Yes.
Okay, good. Let me jump to the jurisdictional question here. So if the trial court did not have jurisdiction to modify the final judgment, and let's say that's what we find, then aren't we just remanding this back to vacate the trial court's order? I mean, because I see here you're asking for the relief of that we find that the former wife should be entitled to X amount. But under Bridges, aren't we bound just simply to vacate the trial court's order on remand?
No, Your Honor. I think it's a 2-part process. Number one, the judge admitted several times in her dialogue with counsel, as well as in her order, she admitted I have no ability to modify this final judgment. The judgment.
But looking at the order, by saying that the parties now, years later, agree that the value at the time was 0, that contradicts the stipulation that the court affirmed back when the final judgment was entered. And so it does appear to be a modification, and I know that's your point. But my question is if we find that way, and I think, aren't we limited to simply vacating this court's order? Because if the court did have jurisdiction to modify it, and we find that it didn't, then there's nothing left for us to do other than to vacate that order and send it back.
Or grant the enforcement not the modification, but grant the enforcement of the terms of the final judgment.
Okay, and then that leads me to my second part of the question here is, okay, if the trial court is somewhat in a dilemma, because the court, if the court were to grant enforcement, the evidence that the parties put on was that the value of that was 0 because it didn't exist, right?
No, Your Honor. No, Your Honor. That's one of the fundamental misunderstandings of this order. And I think the best thing I can do is to go through this because, and I want to say this as graciously as possible, this order is riddled with inconsistencies and statements that are just not factually correct. Let me run through them and say just exactly what they are. And I'll start in reverse order because you point to number 15 where it says the parties do not dispute that the value of the former husband's interest in Optimum was zero. That was disputed throughout the case. As a matter of fact, the court on page 165 of the record, and let me quote what the court said, which was in stark contrast to what they wrote in the order. On page 165, when she's speaking of the $200,000 valuation, she says, but there was value attributable to this asset, and I'm quoting, it hasn't been distributed. As it was valued by the court at the final judgment, it is final. The motion for rehearing was denied. It wasn't appealed. But nonetheless, the court puts in paragraph 15, the parties do not dispute the value of the former husband's interest in Optimum being zero. The only place that was mentioned was at the end of the husband's final argument, to which I replied, I guess, attempting to address it, I said, that's poking your finger in the eye of the wife with facts that just aren't correct. In addition to that, as you go through the court's findings, as we go through this order, you go to number 7, where the court suggests that the portion proposed by counsel is a 50% value of AFC. We never proposed that. That's totally, wholly inconsistent with what our evidence was, our argument was, and the testimony was. I don't know where that finding came from. In paragraph 8, the court says, I admit I have no jurisdiction to modify the valuation because that would be impermissible. But though it goes on down below and says in paragraph 13, there was no evidence that the husband was deceitful in providing the valuation of his interest in AFC. Quite the contrary. The sworn testimony and the valuation of his documents, which he never contested, submitted by him, submitted by his experts, submitted by our expert, put a value on this asset and said it would be divided. Nothing further was needed to be done because, as this court knows, many times when there's small business companies and there's questions as to valuation, the easy way for the court to handle that is to just divide it in half. That way you don't risk benefiting one party or perhaps robbing the other. In paragraph 14, the court says, this is perhaps most perplexing. I'm quoting from 14. The court will find that the asset titled Optimum Healthcare shall be divided equally between the parties based upon the value of the former husband's interest at the time of final hearing. The law of the case, she had ruled it was $200,000. Now, does she get passive appreciation on that going forward? That's the Janke case. That's the Janovic case. That's several other cases that the second district has ruled upon. Where it's done.
Mr. Park, so you mentioned the Janke case, but the Janke case was on a motion to vacate the final judgment, and we don't have that distinguishing fact here. That was a Rule 1.540 motion, if I recall. And there was actually a pleading. And the motion here is simply to enforce. There's no corollary pleading for the relief, I guess, that you're seeking here. So I see Janke a little bit differently than the trial court did on those facts. And I realize she distinguished it on some other grounds, but I don't see the factual similarity with Janke where we don't have a pleading with the relief and where we don't have a motion to vacate the final judgment at the same time.
Well, I think Janke, and I mentioned Janke as well as Janovic, because those are the cases that basically talk about the court as a court of equity can fashion a remedy to provide what I think they called an equivalent benefit to what was awarded.
But that's it. That's the point, is to fashion a remedy. And if the only thing that is sought is enforcement, I'm curious your response as far as whether your motion has gone too far in asking for the relief where you've only sought here a motion for enforcement.
Well, I think the enforcement would be to order basically either the asset to be transferred as was ordered by the order, or in his failure to be able to do that, as these very cases describe, to prescribe an equivalent benefit, which would be a monetary judgment. I think both those cases contemplate that, Your Honor. Because that's the remedy the court would have here. This is not setting aside the entire judgment in 3 years of litigation that's been characterized by this husband's dishonesty.
But if he wasn't hypothetically, if he wasn't able to produce the asset then shouldn't the parties have moved to modify the final judgment? Because you just said if he wasn't able to produce the asset.
I know of no case law in Florida that would allow me to modify the final judgment. I can enforce it. And if it cannot be enforced because of his misdeeds, his dishonesty, his deception, his concealment, then the court can fashion a remedy.
Okay. But with respect to this asset, we don't have the benefit of any trial transcript of what happened at the final hearing on the dissolution. We are only left with the final judgment. And with respect to this asset, the Optimum Healthcare, the only evidence we have now before us is the hearing immediately below, where the court did not find any deceit or fraudulent behavior, correct?
No.
Okay. So
no. I think perhaps, again, one of the most perplexing comments in this order is found in basically number 12, where it says Dr. Chalaverry did not attempt to hide his stock in Optimum. He listed on the financial affidavit and made no objection to its listing in the final distribution schedule. The court makes no findings as to why the former husband allowed the asset to be listed in the schedule if he no longer owned the stock. Well, I can't force the court to make rulings, but the reason why is because if I take the red box and I put it inside the blue box and I convince the court to split the red box with my wife and I keep the blue box, and later after 4 years say, oh, by the way, the red box is contained within the blue box, I get to keep everything. That's what happened here. I don't think there could be any more manifest dishonesty than that. And with the history of this case, which is in our brief, which I hesitate to go into at length, but you can see what it is through Judge Muscarella, who was then recused, through Judge Coleman, who then made a finding of attorney's fees based on inequitable conduct, and then to find out that this has happened later when the husband sells all these assets, including the asset he was supposed to split with his wife, which was concealed in the other asset. I think the remedy under Genovic, under Jankovic, under Montanez, and under I think it's pronounced Demores in our brief, all those talk about the court of equity being able to fashion a remedy to provide an equivalent benefit of what she should have had. Now, whether that's half the $200,000 plus interest, the $200,000 plus passive appreciation, which we suggested should have been by our expert testimony, or something else. But to say it's based on zero, which there's no evidence in the file at all that anyone ever suggested except counsel for the husband. I think if you read this order, again, with due respect, it is riddled with findings that do not reflect many of the things the court even said in the dialogue with counsel, but basically is a summary of the last 5 minutes of husband's final argument, including statements for which there's no basis in the record. So our response is, and I'm not sure where I am on my time, yes, I believe the court has to vacate the order, has to send it back. Yes, I think we affirm what the court said, that no, she did not have ability to modify the final judgment, but she does have equitable powers and equitable remedies to effectively make this lady whole for what she should have received and would have received, but for the overt dishonesty of her husband through his testimony sworn right before the trial where he said he owned it, through the valuation of his documents presented not only by our accountants, by his accountants as to what his value was. And I think that remedy is something the court can do by way of enforcement. And there's no jurisdictional problem with that enforcement because this court, your court, has on multiple occasions done that very thing. I don't know if that's answered your question, but I hope it has. Going forward, I have relented from going through the history of what I've termed the dishonesty of the history of this case, but I think it does show up in what's happened here. The problem was caused by the husband's deceit, dishonesty, and concealment. And all we're asking the court to do is to acknowledge that, to fashion a remedy because of it, and make the wife whole for what she would have received. And by the way, another thing the court said here in paragraph 7, where the portion proposed by counsel is based on a calculation that Optimum comprises 50% of AFC. That was never argued, never asserted, and there was never any evidence presented that. It was a pro rata computation that our expert forensic accountant provided based on the fact that what we have here are two companies, one hid within the confines of another, which were worth more when it was sold for $1.4, $1.5 million. And all it needed to be done was have it be prorated based upon the values the court used at the time of trial, which frankly would have been a fractional interest of 100 over 300 and I guess 35, half the 200 versus the 335, which was the totality of the assets. And I believe that would have been the appropriate remedy for the court to award to make this lady whole. Otherwise, why would the court have to strain so far to basically reward nothing more than the dishonesty of the husband, which is the genesis.
Counsel, you're at your 5-minute rebuttal time.
Thank you, Your Honor. I'll complete it.
Mr. Maros.
May it please the court, I'm Peter Maros. Good morning. I represent the appellee, Dr. Chalavera. Let me begin with commenting on Mr. Park's statements that somehow this final judgment entered by the trial judge related to the dishonesty or concealment of Dr. Chalavera. That is not only inaccurate and not only completely contrary to the direct findings of the trial judge, but is based on absolutely zero evidence of any nature, nothing other than simply Mr. Park seeking to insult this gentleman based on nothing whatsoever that happened at this trial related to these issues. Nothing, zero. And that's exactly what the judge found. To the contrary, Dr. Chalavera had nothing to do with the fact that David Harper, the former wife's CPA, who testified very honestly and honorably before the court, as he always does, that he was the one to choose not to go any further into the valuation of either of these entities, not because of something that was done in the way of concealment. To the contrary, things were listed such as Optimum that had values many years ago and zero value now. He laid the cards on the table completely.
Maris, can you hear me?
Just barely, Your Honor. I have a hard time.
Sorry, my monitor sometimes my speaker, but I'll try to talk a little bit louder. So my question, just to follow up with what you're saying there, is, and to kind of circle back to my jurisdictional question that I was asking Mr. Park, the issue I have here with how the judgment was dealt with below is the parties here actually stipulated to a value for this investment, right? They stipulated at the dissolution hearing to a value of $200,000. This was something that the court approved and a final judgment was entered. And looking at this order now, where it says the parties have agreed that the value is zero, can't you agree that that's a modification of the value of the final judgment of dissolution?
No, Your Honor. It's very easy to understand your comment and why you asked that. But in fact, the case is they didn't stipulate as to any value at all. Back in 2009, if you will notice.
Well, no, I mean, I was looking at the final judgment and the language of the final judgment that said that the parties have stipulated to the matters on the equitable distribution. And so I can only go by what the final judgment says, since we don't have the benefit of a transcript and the final judgment was never appealed. So we're left with what the language in the final judgment says. And it does say that the matters on the equitable distribution are stipulated to. So if that says that the value of Optimum Healthcare, that investment, is $200,000, and the court now says in a new order that it's zero, it would seem to me that would be a modification of the final judgment that was improperly done by the trial court.
No, ma'am, there's no modification here. If you will look at the far right column, first of all, I accept everything you say for purposes of equitable distribution. Everything on the equitable distribution worksheet was either determined by the court as res judicata. There's no argument. But the far right column is the equitable, far right two columns is the equitable distribution worksheet. Those have specific values. For example, the $135,166 on the second page related to AFC. Optimum simply has a to be divided based on an old 2009 value that was not updated. The reason for that is specifically, if there's any value later determined to that property, it would be equally divided between the properties. The $200,000 does not in any way figure into the ultimate $1.76 million that each of the parties are receiving. So the reason that's done, and it's done commonly, and Mr. Harper comments on it, Mr. Berg comments on it, both of the CPAs, if that asset is determined to have value at some point, it should be divided to protect the parties. And here, and it was agreed upon that it has no value, and I'll get into that in a minute. Here, if it was divided at $200,000, there wouldn't be a modification at all. It would be wife gets $100,000, even though it has no value. Husband gets $100,000. There is no change to equitable distribution. There is nothing to enforce. This goes further on page 88 of the transcript. In direct response to your question, didn't everyone agree it had no value? Mr. Harper specifically testifies that based on the information that he has, that there is no value whatsoever to Optimum, not a dollar, and that was something that was clear as a bell.
Let me direct you to paragraph 3, page 16 of the final judgment. It says here, the court hereby, the court hereby determines that each of the assets addressed on the equitable distribution schedule are valued at the values listed therein. I don't know how it could be any clearer that if they put $200,000 and the judgment was entered on the date it was entered, that's the value that the party stipulated to, because the order then says the court hereby ratifies and confirms the allocation of the party's respective assets. So, I mean, I understand what you're saying, it's to be divided, but if that was the valuation the parties picked at the time of the final judgment, isn't that, I mean, don't we have to, aren't we bound by that value?
Yes, Your Honor, you're bound by what's on that equitable distribution worksheet in all respects. But from any point of view you look at it, whether it be the wife's or the husband's, the $200,000 was not figured into equitable distribution. And if later to be divided, and if you take the $200,000 figure, even though we know it's zero, it would still be 100 each. There's nothing to enforce, nothing to modify whatsoever. This was simply a recognition by the trial judge in a very well-written order that there's nothing left to be divided of that $200,000. If it was to be divided, if you, as you're suggesting we do, should accept the $200,000, it would make no difference. It's $100,000 each. Nothing happens. An order of enforcement, as stated by the judge, nothing to be divided is nothing. 200,000 to be divided is 100,000 each. It has nothing whatsoever to do with equitable distribution. This is a simple matter.
I have a question for you that maybe I'm under the misunderstanding, but my reading of the order denying respondents' motion to enforce equitable distribution under paragraph 4A, isn't the judge saying that the Optimum Healthcare stock, that there really wasn't even any ownership of the Optimum Healthcare stock at the time the final judgment was entered?
Absolutely, Your Honor.
I mean, what it looks to me like is the court is making a finding that Optimum Healthcare stock disappeared as of October 3rd of 2007 and was folded, in essence, folded into another category. Is that right?
I'm sorry. Yes, sir. That's 100%.
For some reason, there's a $200,000 value given to an Optimum Healthcare designation on the equitable distribution sheet, but that looks to, I took the court's more recent order as saying that was a mistake. Shouldn't even have been on there.
No, sir.
Am I misunderstanding that?
I don't think it's a mistake or a misunderstanding by you. What it is a recognition of the fact that the AFC stock, which was charged as an asset distribution to Dr. Chalavera included the full value of the Optimum Healthcare
That's what
stock.
I'm trying to say. That the Optimum stock was folded into the AFC.
It was traded in 2007, 7 years before the final judgment, and was included in the full value.
And that's why the court is now finding that they can't figure out what all's in the AFC box. It was Optimum along with other things, and the court can't value that. Am I right about that?
Well, what the court is talking about there, Your Honor, is that subsequently when it was sold, when AFC was sold, subsequently to Anthem years later,
right,
that there was no evidence of any nature to determine that there was any value to Optimum versus the other entity involved, their Freedom, and you couldn't possibly try to forge some kind of judgment without any competence and substantial evidence. The bottom line is, and it's uncontroverted, that 100% of the value of that stock, Optimum, whether it be 200,000 or zero, was folded into by a trade in 2007. All of Optimum for all of AFC, all of that was charged to Dr. Chalavera, and Mrs. Chalavera got 1/2 of that without any question whatsoever.
So that Optimum entry really should never have been on the equitable distribution chart to begin with, should it?
No, I think it's fair to have it on there, just like it's fair to have, I could give you lots of examples, like, whether you have American Express points that you don't have a current value for, that had previously been turned into rewards points, or a bank account that you have an all balance to. The CPAs in good faith put in anything that's on the financial affidavits that they don't have a current value on as to be divided, to be protective of everyone. Okay. I don't blame Mr. Harper, the former wife CPA, from doing that, but it has zero value.
All right, thank you.
Yes, sir. So to make a long story short, in completing what I have said, this trial judge recognized that in 2014, when this case was resolved, that every single asset was equally divided between the parties, equally, 1.7 million each. Hers included specifically any value to Optimum, which had been transferred 7 years before the final judgment into the value of AFC. She got 1/2 of that. It would be a modification, and a matter of fact, as Judge Smith pointed out, would in fact be an attempt to set aside the prior final judgment by a 12.540 motion to show that something else should have been included that had absolutely zero value. This is no different whatsoever than if after the date of the final judgment, the wife's property ended up being worth 3 times what it was as a result of passive appreciation. That's all that occurred here, all. Thank you, that's all I have.
Okay, thank you. Mr. Park, you have your 5 minutes.
Thank you, Your Honor. I think the problem we have here is the same confusion being suggested here that I think confused our trial judge, and that is we have a set of facts that we know in 2019 versus a set of facts presented through sworn testimony and documents in 2014. And the set of facts in 2014 were based upon evidence this court relied upon, evidence that was based upon what the client said under his sworn testimony and his deposition at the record of 2136, which was false, based upon documents he presented based from his bank and his own financial affidavits, which were false as to this asset, and never told the court that basically the asset existed, but it existed under another guise by being within another asset. That's the essence of what happened in this case. So the whole idea that somebody stipulated the value of this asset was zero is just incorrect. There is nothing, I repeat, nothing in this record that suggests that. Where that finding came from, I have no idea, other than it was laid in the final argument of the husband. The asset has significant value. The idea of the valuation too, your court's well aware that in our practice as practitioners now, many times in these small business companies where valuation is a troubling consideration, the court where it's going to divide it isn't considered as much about valuation. The court must put a valuation on it because the statute requires the court to do that. The court did that. We used the valuation based on the best evidence we had. We now know from what we found out in subsequent depositions that the husband had kept information from us. He kept information from his own lawyer. He kept information from his own forensic accountant. And that's the best numbers they had at the time for the valuation of this company. He also kept the fact that it didn't exist in his name anymore and was owned by another company that he owned. That's the one he later sold later. So we get into the whole issue of, is there a modification of this judgment by what this court did? Yeah, it took Judge Muscarella's valuation and negated it and discarded it and substituted a value of 0 for it.
Mr. Park,
Yes.
I've got a question on the order with respect to, I believe it's paragraph 4 on the second page. The court makes a finding, and I'm just curious how this might have played into the ruling, is the court makes a finding that the asset, which is the America's First Choice Holdings of Florida, is valued at $135,166, was divided equally between husband and wife and distributed as same within the schedule. And I'm looking at the schedule to the final judgment, and I don't see where that asset was divided equally. It was actually all to the husband. So is that something that the trial court confused?
I always hate to use those kind of words when I describe what the trial court did. Let me just suggest to you it was inconsistent with the record. It was inconsistent with the evidence. And I don't know what the basis for that statement was, because nothing could be further from the case. The husband received all of that, while the parties split the larger asset, which we now know was contained within that, which is an interesting mathematical computation, how the larger box can be hidden in the smaller box, except by the deception that was practiced by what was told here. So no, there's no basis for that at the time, that valuation was that asset was split. If that had been the case, then that would have been very simple. When the husband sold his AFC stock, the parties would have divided the money. That was not the case. And I think that's an interesting commentary in light of some of the other commentaries of the trial judge about her perceptions of this judgment, which again, I would respectfully suggest are basically recitations of what she was told in the final argument, overlooking the fact there was no evidence to support that. I go back again to what the judge said at, I believe it's page 171 of the record, where when Mr. Maris was arguing about there's no value to this asset, she says, and I quote, "There was value attributable to this asset. It's been distributed and it was valued by the court at the final judgment. That's final. It is final. The motion for hearing was denied." By the way, Judge, you had indicated, just so the record's clear, that it was never appealed. This judgment was appealed. Everything that's been done.
I misspoke. Yes,
Everything in this case has been appealed. That was appealed. The first enforcement proceeding was appealed, although it was dismissed. So we have consistency, at least in terms of appeals in this case, where things occur. So I don't know if that's answered your question on that one paragraph of the judgment. It gets back to my point, which is why is there such a strain here through, with all due respect, incorrect findings of fact and conclusions of law to basically reward the husband for what was basically his overt dishonesty and what he did in portraying this to the court. Where the law of the case is still viable in Florida. There is a law of the case here that says this asset had a value of $200,000 and was to be divided. And that asset under these cases, the second district has affirmed on several occasions we've talked about, says that there's an equivalent benefit to my client.
Mr. Park, you're at your 5 minutes, so you need to wrap it up, sir.
Okay. I would just say that it gives the court the ability to make a remedy that makes her whole for not only that, but the appreciation she's entitled to. One final thing I think Mr. Maris agreed to. We had a reservation of jurisdiction for attorney's fees. We filed a motion for rehearing to point that out to the court. Mr. Maris didn't even oppose it, and the judge denied that too. So I think on his face, we haven't even disagreed about that. I don't know why that was denied, but that was agreed to in the course of our trial. And when we tried to bring it up with the consent of Mr. Maris, who was very straightforward about agreeing to that, the court denied that also. So I would ask that this be reversed with instructions to, as we have, provide the relief we requested and allow for the attorney's fees issue to be resolved based upon, among other things, the inequitable conduct doctrine, as it was last time. Thank you.
All right, thank you.
Judge
We'll take a 10-minute break and come back for the last case.
Thank you, sir.
Judge Black?
Yes.
Can you hear me? I'm sorry. Before we conclude, Judge Smith, I've never asked this before, but Judge Smith asked a question that has left the court with something that's very, very incorrect on the record. Can I briefly respond so we don't make a mistake? Very briefly, 1 minute.
I can't let you do that. I'm sorry. If you feel you need to do something, file a request with the court.
I had to ask. Thank you, Your Honor.
All right. Thank you. We'll be in recess for 10 minutes.